rise if able. In the matter of bans and FM Conway Limited and another.
Yes, Ms. Boone.
Good morning, milady. This is an appeal arising out of a decision of Mr. Justice Jacobs on the 27th of February 2024. I appear on behalf of the appellant, FM Conway, who I will refer to throughout as the first defendant, given that the underlying matter also related to an application as against the second defendant, Westminster City Council. My learned friend, Miss Corrigan, appears on behalf of the claimant.
Yes.
Milady,
just before you launch in, Ms. Boone, if I can just tell you, we've all had an opportunity of reading the papers, dipping into the primary authorities, and so and of course read your skeleton arguments, for which thank you both. So we're very familiar with the case.
Milady, I'm extremely grateful. There was a preliminary issue raised by the court at the end of last week, and that was given that the case has thus far been conducted on the basis that the relief from sanctions regime applies. A query was raised as to whether or not that was mistaken, given that CPR 7.4 nor the Commercial Court Guide provides an express sanction in relation to a failure to serve particulars of claim in time, and your lordships referred us to the decision of Yes Electrical and Warren, which was a 2024 decision of January this year.
Ms. Boone, we've had your helpful email of the 1st of November, your joint reply between both of you, and I think we're all content. That answers the query that was raised.
Excellent.
I don't think we need to hear any submissions.
You'll be very pleased to know that my supplemental bundle of authorities on implied sanctions I will therefore put away.
No, absolutely, yes. We're very focused on the key point in this matter. Thank you.
It wouldn't be an implied sanction case anyway, would it? Because you say it's the third category in
I do,
X, which is an express sanction.
I do, my lord, and I do say that it falls in the third category. In the alternative, I was happy to address you on implied sanctions if you were against me, but happily we don't.
All right, well, if you both agree the primary analysis, we probably don't need to go any further.
I'm grateful. The nub of the issue, as you will have seen from the papers, is whether or not it was legitimate for Mr. Justice Jacobs to take into account two matters. Firstly, a pre-action admission of liability, which it was agreed both between myself and my opponent at the time, Miss Berzio, and also accepted by the court, that that admission had been validly withdrawn. And secondly, whether or not it was legitimate for Mr. Justice Jacob to take into account the underlying merits of the case, given that first of all, no defence had been filed on the part of the first defendant, as the claim had already been struck out pursuant to the order of Mr. Justice Bright, and of course, per the decision of the Supreme Court in His Royal Highness Prince Abdulaziz, it is my primary submission that the underlying merits are only relevant where the claim is such that it would succeed on a summary judgment application. You will see from my skeleton argument that I have three grounds of appeal. The first is that the judge misdirected himself in law and applied the wrong test. He set the threshold too low, namely he applied a test of a very strong case as opposed to a summary judgment test as to whether or not the claim was unanswerable. Secondly, that the decision was unjust, because as at the time of the relief from sanctions application, there was no application before the judge to withdraw the admission. It was agreed it had been withdrawn, and there was no application before the judge for summary judgment. My opponent at the time, Ms. Berzio, had not indicated that she intended to rely on the admission or the merits or the strength or otherwise of them prior to that application. And the judge found that given that there was no defence before the court and no other material before the court on which he could assess the merits, that was therefore an inference of a very strong case. And in my submission, he was wrong to do so, given that that was a point in time when, as I say, a defence has not been served. And my third ground is namely that even if the legal test was right, and even if the judge was entitled to take into account the admission and the merits of the underlying claim, that nevertheless he balanced the factors unfairly. And I say that because, as between the first defendant and the second defendant, both parties had applications before the court for effectively relief from sanctions, and the judge granted relief from sanctions in relation to the first defendant and refused relief from sanctions in relation to the second defendant, notwithstanding that, in my submission, the underlying circumstances were weighed much more heavily in relation to the first defendant. There was a more serious breach. The claim had already been struck out, and therefore the underlying sanction is deemed to be proportionate, and the only difference between the parties was therefore the pre-admission which had been withdrawn. And in those circumstances, I say that that is not something that should have tipped the balance in the favour of granting relief as opposed to refusing relief. Milady, I note, and I'm very grateful that you are familiar with the papers, so I don't intend to take you at length through the background. I highlight three, however, findings from the judge. The first is in relation to the status of the pre-action admission. There was, prior to the hearing, a dispute between the parties as to the status of that pre-action admission. The claimant, and it was not my learned friend, it was Miss Berzio, but the claimant argued that the pre-action admission could only be withdrawn upon application and permission from the court, and therefore, in her skeleton argument, she said she was entitled to rely on it, and effectively the only matter for the court was one of quantum. The first defendant argued that it had been validly withdrawn as at April 2021, because as the rules then applied, it did not need permission from the court. And the long and the short of it is that Ms. Berzio conceded that both the rules she relied upon, namely CPR 14.1a, as it was then in force back in 2021, did not apply to a case of this nature because it wasn't a personal injury action or a medical negligence action. So it was conceded, and the judge also accepted that that admission had been validly withdrawn. And your lordships, that is not something that is challenged by the claimant today, and that is particularly important, and we can see that in her skeleton argument at tab 3 of your core bundle, page 39, paragraph 34. It is accepted that because the withdrawal of the admission took place before the reformulated CPR rules came into effect in October, that the withdrawal was effective. The consequence of this means that the claimant would not be able to gain summary judgment on the basis that there had been an admission. So there is no dispute between myself and my learned friend that the admission was A, validly withdrawn, and B, had there been an application for summary judgment either prior to or at the relief from sanctions application, that is not an admission that she could have relied upon in support of summary judgment application. So this, against that background, the judge then went on to address the relevance of the pre-action admission.
Well, why is, I mean, she might have conceded it, but why is it right? I mean, the fact is that an admission was made by an experienced loss adjuster, which is not something they generally go about doing without good reason. Why would that not be at least evidence combined with, if appropriate, the strength of the case on which, if there had been a summary judgment application, the claimant could have relied?
Well, had there been a summary judgment application, I accept that in relation to a summary judgment application, then of course the court is looking at the merits of the case. But had there been a summary judgment application, then equally the first defendant would have turned up armed with arguments as to why it said that summary judgment ought not to be granted. That was not an application that the court was hearing at the time, and therefore, in light of, in my respectful submission, the clear case law of the Supreme Court that merits are not something to be taken into account absent summary judgment, that was not something that the first defendant was required to address.
well, you'll take us to the case law, but does the case law say that absent a summary judgment application, you mustn't address it, or merely that if it's not the kind of case which would be suitable for summary judgment on the evidence as it currently appears, then you don't address merits?
Well, my lord, I think it probably would be helpful to take you to the authority so that we're all
Well, I mean, if you're coming to them later, don't go out of your way. But I mean, that's the point which
no.
you might
So
want to
the point that the court makes is the point that the court makes is twofold. First, that the test to be applied is whether or not the merits of the claim are unanswerable, i.e., such that it would be suitable for summary judgment. So that is the test. But equally, at paragraph 34 of the same judgment, Lord Neuberger says that it would risk unfairness to hold that a party had an unanswerable case, given that unless the point had been flagged up in advance, and that if at an interlocutory hearing, which is not a summary judgment hearing, a party wishes to rely on the contention that they have an unanswerable or a very strong case, then they are obliged to raise that in advance. That's paragraph 34 of the Global Torch decision. So I rely on that authority for 2 points. Firstly, what the test is, and secondly, the procedure by which a court, if it is invited to look at the merits, ought to do so. Summarising then, the pre-action admission, it was agreed, had been validly withdrawn, and the test, which is behind, in the authorities bundle behind tab 6, which is the authority which I've just been referring to, on page 93 of the authorities bundle. At paragraph 29, it was said that the strength of a party's case on the ultimate merits, and I'll come back to the ultimate merits, but a strength of the party's case on the ultimate merits of the proceedings is generally irrelevant when it comes to case management issues.
Sorry, where are you reading from?
Paragraph 29.
29, sorry, I misheard you.
Sorry, my lord.
No.
The strength of a party's case on the ultimate merits of the proceedings is generally irrelevant when it comes to case management issues of the sort that were the subject matter of the decisions of Voss, Norris and Mann. Mann, obviously, dealing with a relief from sanctions application. The one possible exception could be where a party has a case whose strength would entitle him to summary judgment. Both the general rule and the exception appear to be common ground between the parties, and the general rule is justifiable on both principled and practical grounds. And then at paragraph 30, the court held that it's hard to see why the strength of either party's case could affect the nature or the enforcement of those decisions and directions. It's hard to identify quite how a court, when giving directions or imposing a sanction, could satisfactorily take into account the ultimate prospects of success in a principled way. It would be thoroughly undesirable if every time the court was considering the imposition or enforcement of a sanction, it could be faced with the exercise of assessing the strength of the parties' respective cases. It would lead to such applications costing much more and taking up much more court time than they already do. It would thus be inherently undesirable and contrary to the aim of the Wolf and Jackson reforms. And we can see that at paragraph 31, in terms of procedure, the rationale was that where a party has a strong enough case to obtain summary judgment, then obviously they wouldn't ultimately have to go to trial. And therefore the risk in considering the ultimate merits would be much reduced. Unless the court can be quickly persuaded that the outcome is clear, it should refuse to consider the merits. And then at paragraph 32, one of the issues was whether or not a very strong case, which is how the Prince had put the level of his prospects, was sufficient to satisfy that test. And Lord Neuberger said, I should add that I do not think it would be enough for a party to show that while his arguments were not strong enough to justify summary judgment, his arguments were strong enough to justify the other party being required to bring the disputed sum into court, so payment into court. For present purposes, as with an outright order for summary judgment, a claim or defence is either unanswerable or it is not. And finally, paragraph 34, the paragraph which I referred your lordship to, in relation to arguing these matters, it would risk inherent unfairness to the apex parties to hold that the Prince had an unanswerable case, as that point had not really been flagged up as part of his argument until the Prince was given permission to appeal to this court. It does not appear to have been claimed that he had an unanswerable case. Even in his printed case for the appeal, the Prince is described as having a very strong defence on the merits, not an unanswerable defence. If, at an interlocutory hearing, which is not a summary judgment hearing, a party wishes to rely on the contention that he has an unanswerable claim or defence, it seems to me that he should spell out that contention very clearly in advance, as otherwise the raising of the contention at the hearing could wreak obvious unfairness on the other party. And so, against that background, nevertheless, the judge went on to find that the pre-action admission, despite having been validly withdrawn, could not be disregarded as irrelevant, and that it was permissible to take it into account when considering all the circumstances, and further, that when looking at the merits of the underlying claim, he was entitled to pay regard to it when considering whether or not the case was very strong or very weak. It was uncontroversial that, given that the claimant's claim had already been struck out, as at the time of that hearing, that the first defendant had not yet filed a defence. It also obviously hadn't served any expert evidence or any witness evidence at that time. And equally, in light of paragraph 34, given that the claimant had not raised any argument about the strength of the underlying merits, notwithstanding the erroneous contention that they could rely on the admission because it required permission to be withdrawn, evidence as to the factual and legal basis of the defendant's defence was not before the court. That defence was, of course, not filed until the 22nd of April 2024, and of course it wasn't before the court, but it is in the core bundle behind paragraph 10, behind tab 10.
Is there evidence that it was because the claimant had not raised the argument that your side did not address it, or is that submission?
It is submission, as at, I of course have to be careful that I don't give evidence to this court, but at the same time, obviously, I appeared in the underlying hearing. The first defendant's primary submission at the underlying hearing was that merits were entirely irrelevant because, as per the decision in the Supreme Court, they ought not to have been taken into account unless the claim was suitable for summary judgment, and absent the admission, the claim was not suitable for summary judgment because it was a claim in negligence and there are a number of issues that were raised. However, the nature, factual and legal nature of the defence itself was not before the court at the hearing on the 27th of February.
Can I wind back a touch?
Of course.
There was a dispute between the parties before the hearing, i.e. going into the hearing, as to whether permission was required for the admission to be withdrawn.
Well, there was a dispute insofar as the claimant's counsel relied on the admission as one that she said, therefore, A, she was entitled to rely on it, and therefore the only issue between the parties was quantum. But there was no allegation raised by the claimant that, admission aside, the strength of the underlying merits was such that it was a case that would have been suitable.
No, that's not quite the point I was making. As I understood it, and as I understood paragraph 11 of the judgment, before the argument or before the hearing, in the run-up to the hearing, it was being said on one side, you needed the court's permission to withdraw the admission, and on your side, I think you were saying no, we didn't.
Yes. The first defendant was not saying no, we didn't. The first defendant was saying we've already withdrawn it.
Okay, well, we didn't.
At the time.
We could.
We didn't because we could and we have.
Yes, in other
Yes.
words, we didn't need the court's permission
Yes.
to. They were saying, I think, you did need the court's permission to withdraw. Is that right?
Yes.
If you were wrong on that, what would be, in other words, if they had been right, that you needed the court's permission to withdraw the admission, the merits would have been relevant to that exercise of discretion by the court.
Well, in relation to it depends whether or not the rules that would have been applied were the rules under 14.1a as they were in force at the time that the admission was withdrawn in April 2021, or whether or not they were the rules that were in force post October 2023. My learned friend sets out those rules in her skeleton argument, and in my submission, applying those rules, they're on page 40, my lord, of the core bundle. Applying those rules, I say that the first defendant would nevertheless have still obtained permission to withdraw the admission, applying the rules as they did post October 2023.
Yeah, you may well be right about that, but would not the merits have been relevant to that?
Yes, the prospects of success would have been relevant to that application had it been made, but that was not the application that was before the court at the time.
But the question of whether you needed permission was one that was live running into the hearing.
Well, no, my lord, because the claim had been struck out. So as things stood, as at the date of the hearing, the claim had been struck out. There was no live claim. Unlike the position of the second defendant, who was applying to strike out, so there was a live claim, as at the hearing in February 2024, in relation to the first defendant, my client, there was no live claim. The claim had been struck out on the 27th of July 2023. That's the order of Mr. Justice Bright, which you can find in the supplemental bundle on page 37. So there was no live claim as at the date of the hearing. So whether or not the question of the admission was two stages removed irrelevant in my submission. Firstly, the claimant needed relief from the court in order to get any claim back into play. And then secondly, having got relief to get the claim back into play, there then may or may not have been a secondary argument as to whether or not that admission could or couldn't have been withdrawn. But those two, this is indicative in my submission of the error of approach that was taken. Those two stages were conflated. The judge was looking at the merits of a claim that had already been struck out instead of focusing on the regime under Rule 3.9.
Thank you.
The judge held that the admission couldn't be disregarded as irrelevant, and in relation to merits, he held that he was entitled to take into account the fact that he didn't have a defence before the court. And in my submission, that is plainly unfair and wholly unjust in circumstances where a claim has already been struck out and therefore time for a defence has not arisen, in circumstances where the underlying merits ought not to be considered at a relief from sanctions application, and in circumstances where my learned friend Miss Berzio at the time had not, other than the erroneous contention that the withdrawn admission could be relied upon, that the underlying merits weren't in play. And so there was no defence before the court because one had not been filed. And what the court were doing in my submission that was an error was that the judge was looking at what he had before him on the present materials, so a point in time, which when we look at the decision of Abdul Aziz, we can see that what the court is talking about is the ultimate merits, so the ultimate prospects of a case. Of course, if one was to come before the court on a summary judgment application, the judge would have all of those factors at play because the parties will be preparing for a summary judgment application. At the relief from sanctions application, the judge didn't have before him a defence, he didn't have witness evidence, he didn't have expert evidence because they're all matters that hadn't yet been obtained because the claim had been struck out.
Was there any submission to the judge that he was not entitled to look at the merits, however strong he thought they were, because that was simply not in play?
Yes, I think it's also reflected in the judgment.
I mean, was he taken, for example, to paragraph 34 of Global Torch?
Yes, so you can see, my lord, at paragraph 26 of his judgment, I'm behind tab 7 of the core bundle.
Paragraph 26, did you say?
Paragraph 26. One particular issue that's been debated in argument before me is the relevance or otherwise of the admission. It's now common ground he's entitled to withdraw it. On behalf of the first defendant, Miss Boone, submitted to me in forceful terms that anything said in relation to that admission is wholly irrelevant. She's referred me to the discussion in paragraph 3.9.20 of the White Book under the heading whether the defaulting party's claim or merit has defence. That discussion refers to two cases, one of which is a Supreme Court case, Abdul Aziz, and the second case is the High Sarge case. And then in my submission, the judge makes the comment that the Supreme Court case was not in fact a case involving the application of the Denton principles, when clearly it was. It was a case where there had been a failure to comply with the unless orders which had been imposed by the court, which is right, but the Prince was applying to set aside the judgment that had been entered as a result of a failure to comply with the unless orders. And then he sets out at paragraph 27 the relevant paragraph from the High Sarge case, which I'm happy to take your lordships to. That applies to applications for an extension of time for permission to appeal, and so in my submission can be distinguished from paragraph 28 of his judgment. You can see, Lord, that he refers directly to the test in Abdul Aziz and sets out, Lord Neuberger said, even in a striking out of a case, the merits of a claim or defence were relevant only where they were so strong that there was no real answer to them. In other words, in cases where an application for summary judgment could be expected.
Well, there are two separate points, aren't there? One is whether the judge thought that the merits reached the threshold for taking account of them in the context of the decision he had to make. And it looks as if he did. You may say that he applied the wrong threshold. I think that's your first point. But the second and distinct point is that you say he's not entitled even to think about the merits because there's been no prior warning that those are in play. And that's what paragraph 34 of Global Torch is dealing with. And I'm just trying to get to the bottom of the extent to which that was or wasn't right.
Yes, you're quite right. There are two factors that I say the judge took into account which he ought not to have done, but they are, in my submission, related because they both ultimately relate to merits. One is the pre-action admission that was withdrawn, and I say that that is irrelevant in and of itself because it had been validly withdrawn and liability was very much in dispute from April 2021. And the second is, quite apart from the admission, albeit that of course the admission was heavily relied upon in forming his views as to the underlying strength of the case, is that he ought not to have been looking at the underlying merits at all, because the only argument on the part of the claimant at the hearing in February 2024 was that she was entitled to rely on that admission because it required an application to and permission from the court. She did not separately argue that this was a case that was either unanswerable or was very strong on its merits. So I say, both as a matter of law, the wrong test was applied, we ought not to have been looking at merits, but separately as a matter of procedure, we ought not to have been in this realm at all because it hadn't been flagged up prior to the hearing that, aside from the erroneous argument about the admission, that there would be any argument about the strengths or otherwise of the merits of the claim.
Yeah. Now, I'm puzzled because whilst the judge deals with the first point and deals with his view of the strength of the case, there's no hint in the judgment, as far as I can see, that anybody submitted to him that he wasn't entitled to look at the merits because the point hadn't been flagged up. And this is a very thorough judge, so I'm a bit puzzled. Can you help at all?
Well, the judge was firmly told that he was not entitled to look at the merits, not just the relevance of the admission, but the merits overall. And I say that that can be clearly seen in paragraph 26, when the starting point was taking the judge to paragraph 3.9.20 of the White Book, the heading under whether the defaulting party's claim or defence has merit. And so the submission was raised on both grounds. Firstly, that the admission ought not to be looked at, but the merits as a whole were entirely irrelevant on a relief from sanctions application.
Do we have the skeleton arguments in the bundle?
We do, my lord. They're in the supplemental bundle. Paragraph, page 275, behind tab 3. Particularly page 278. This was my skeleton argument for the application, and you can see at the bottom of page 278 there's a heading, response to irrelevant points raised by the claimant. And over the page, paragraph 22, for the avoidance of doubt, to the extent that the claimant seeks to rely on an erroneous early admission of liability, the same is clearly inappropriate. In any event, the same has since been withdrawn, and liability is very clearly in dispute. The merits or otherwise of the underlying claim are not a relevant factor to be taken into account when considering the Denton principles. And then I make a secondary submission, even if they were, it's a poorly pleaded claim and further evidence that relief.
But that isn't the paragraph 34 point.
Sorry, my lady.
That's not the paragraph 34 point.
No,
you're effectively arguing it. You're saying, one, they were wrong in law. We were entitled to withdraw, and we did, and I have all your points on that. But you're saying, in any event, that admission wasn't good enough to achieve the test of summary judgment.
Yes.
You were not arguing that they should not be allowed to argue the secondary position once they'd lost on the withdrawal point, because we haven't had adequate notice.
No, that paragraph in my respectful submission, my lady, covers both points. The first sentence is you can't look at the admission, and the second sentence is the merits or otherwise of the underlying claim are not a relevant factor. So the submission was raised on both bases, that the admission itself was irrelevant, but nevertheless the court ought not to be looking at the underlying merits. We took the court to paragraph 3.9.20 of the White Book, which can be found behind tab 10 of the bundle. On page 156. And this is the paragraph that the learned judge refers to at paragraph 36 of his judgment. This was a paragraph that we went to during the course of the hearing, whether the defaulting party's claim or defence has merit. So, my lady, in my submission, the argument was twofold. One, the admission was irrelevant, but secondly, the underlying merits of the defence were irrelevant. And that one could not look to a withdrawn admission in order to support.
I understand your submission.
I'm grateful.
Just glancing at paragraph 3.9.20, I can't see anything in it which replicates the paragraph 34 point. Am I missing something?
No, the paragraph 34 point, as in it was
Noble tort.
No, as in there was no. Sorry, to be clear, the submission at the hearing in February was made on two grounds. One, that you ought not to look at the admission, and two, you ought not to look at the merits. There was no secondary argument, express secondary argument, that it was unjust.
That's exactly the point I was making.
Sorry, my lady. I was answering two different questions at the same time. My lord, your question was whether or not there were submissions on the two alternative bases, admission and merits. And the answer to your question is yes. both of those arguments were raised.
Oh, well, I didn't make my question as clear as I intended.
You were a follow-up to me, was unjust argued.
Yes. So in terms of the court ought not to be looking at admission or merits, both of those arguments were raised, and that is why I took you to paragraph 22 of my argument. In terms of the argument, was the paragraph 34 argument expressly raised at the hearing? No. My primary submission was simply that we were there and we ought not to be looking at the merits at all. I'm grateful. And I'm sorry for not answering the question clearly.
No, I'm
So I was a little opaque.
Well, I'm sure it's my fault, but anyway, you've cleared it up now. Thank you very much.
So my primary submission is that the judge misdirected himself as a matter of law. First of all, by taking into account the underlying merits, but secondly, by taking into account the perceived
We
omission.
have that.
Now, in relation to the test that the judge did apply, which I think is helpful, is the decision of Haisage, which is found behind tab 7 of your Lordship's authorities bundle on page 105, which is the decision of Haisage of the Court of Appeal. That was an application for an extension of time for a notice of appeal. And we can see there at paragraph 46, which is on page 117 of the authorities bundle, that Lord Justice Morbick says, if applications for extension of time are allowed to develop into disputes about the merits of the substantive appeal, they will occupy a great deal of time and lead to the parties incurring substantial costs. In most cases, the merits of the appeal will have little to do with whether it's appropriate to grant an extension of time. Only in those cases where the court can see without much investigation that the grounds of appeal are either very strong or very weak, will the merits have a significant part to play when it comes to balancing the various factors.
Sorry, I've lost my place. Which paragraph
Not
are you
at all.
at?
I'm on paragraph 46, page 117, behind tab 6.
Thank you.
So here we can see that this is Mr. Justice, Lord Justice Morbick considering whether or not to take into account the merits on an application for an extension of time for a notice of appeal. And at paragraph 46, in summary, he says that in most cases, the merits of the appeal will have little to do with whether it's appropriate to grant an extension of time. Only in those cases where the court can see without much investigation that the grounds of appeal are either very strong or very weak, will the merits have a significant part to play when it comes to balancing the factors. In most cases, the court should decline to embark on an investigation of the merits and firmly discourage argument directed to them. Here, too, a robust exercise of the jurisdiction in relation to costs is appropriate in order to discourage those who would otherwise seek to impress the court with the strength of their cases. And then at paragraph 47, he refers expressly to the Supreme Court decision in Global Torch, in which the court had to consider the extent to which the merits of a claim or defence were relevant to granting relief from sanctions of striking out in default of compliance with a nonetheless order. And we can see that there, even in a case of striking out, the merits of the claim or defence were relevant only where they were so strong that there was no real answer to them. In other words, in cases where an application for summary judgment could be expected to succeed.
Now, paragraph 46 is quoted verbatim by the judge at paragraph 27 of his judgment. So would it be a reasonable conclusion that he must also have had paragraph 47 in mind, and that shows what he meant when talking about a very strong case was the same as what Lord Justice Morbick meant, i.e. the same as the summary judgment test?
Well, no, my lord, and we can see that from his judgment itself. He does, behind tab 7 of the core bundle, which is the judgment, at paragraph 26, 27 and 28, the paragraphs we've already looked at, he does expressly make reference to paragraph 47, But then he says at paragraph 29, which is the crucial paragraph, he says the judgment of Lord Justice Morbick in the Court of Appeal in the context of the application of the Denton principles indicates that it is permissible when those principles are being considered and the court is concerned with all the circumstances of the case to pay regard to whether a party's case is very strong or very weak, provided that can be seen without much investigation. That is the point he was making in 46. He does not go as far in the context of the application of the Denton principles to say that it would be necessary for a summary judgment application to succeed. So in my respectful submission, that is erroneous. Where we are dealing with a claim or a defence and not an appeal, the test is that set down by the Supreme Court, and that is summary judgment. And here, in my submission at paragraph 29, we can see that the judge didn't consider that he was applying the summary judgment test. He considered that it was only necessary to show that the case was very strong or very weak. And taken very shortly then, in my submission, that there was an error of law in applying the correct legal test. In the absence of any argument or finding that the claimant's case was unanswerable, in my submission, the judge should have refused to consider the merits of the underlying claim. If I can move to my second ground, unless I can assist you any further on my first ground.
Thank you.
Milady, just in relation to your earlier question, as to whether or not unjust was being argued, I should probably clarify that the argument about whether or not the claim was very strong or very weak was not a submission that was made by the claimant either. So to be absolutely clear, I did not argue on behalf of the first defendant that it was unjust.
Understood.
But nevertheless, there was no submission made by Ms. Berzier on behalf of the claimant that this was a claim that was either unanswerable or was a very strong case. It wasn't raised until we got to the judgment. Which leads me then to my second ground, which in essence is, even if the correct legal threshold is a very strong case, in my submission, there was no evidential basis for the judge to make such a finding. And the nature of this ground turns effectively on an argument that, given that there was no prior warning or application by the claimant to suggest that this was going to be an argument, it was nevertheless premature, given the moment in time in which we found ourselves, namely at a relief from sanctions application prior to a defence, in order for the judge to attempt to assess the ultimate prospects or the ultimate merits of a case, given that we were at a point in time. The judge found that the admission had been made after consideration of all the relevant facts, and had been made by an experienced loss adjuster looking into all the facts carefully. In my submission, there was no evidential basis at all for the judge to make or infer such findings of fact. There was no evidence before the court at all as to why the loss adjuster had made the admission, whether because they thought that the first defendant was negligent or simply because they'd made the admission for some commercial reasons or otherwise. And the reason that that evidence wasn't before the court was because this was not an application to withdraw that admission. The only factual evidence before the court was the admission itself, and that can be found in the supplemental bundle at page 169. There's an email, I hope, of the 6th of October 2020. Good afternoon, Miss Bangs. It was at a time when the loss adjusters were unrepresented legally. The first defendant was unrepresented legally and was acting via its loss adjusters. Good afternoon, Miss Bangs.
But these are very experienced insurers, no doubt, and Sedgwicks, who send this, are well known in the insurance world. So they may not have had solicitors, but you're not suggesting they didn't know perfectly well what they were doing.
No, my lord. I don't have to go that far. We can look at the admission itself, and then we can look at why it was withdrawn. And they were that was the only evidence before the court. But the very fact that it had been withdrawn and had been withdrawn validly, and we hadn't got to the time of serving a defence, in my submission, it was therefore not right for the judge to draw any further inferences as to the merits of the underlying claim. So, good afternoon, Ms Bangs. I have today returned from annual leave and confirmed that I am the loss adjuster appointed by the insurer of FM Conway in relation to your claim for property damage. We must advise that legal liability for the accidental damage caused to your property is conceded, and this will not be raised in the future. The public liability policy held by FM Conway is underwritten on an indemnity basis. This means settlement will take into account any prior wear and tear and depreciation, and is not on a new for old basis. So in my submission, all that can be gleaned from this email is that a loss adjuster was appointed, having returned home from holiday on the 6th of October, and sends an email advising that legal liability for the accidental damage caused to your property is conceded. I accept that as an admission. I'm not trying to seek to persuade the court otherwise, but it is on its face no more than that. In relation then to the relevance of that to the claimant's claim, which is pleaded in negligence, given that that has been withdrawn, is in my submission unclear. The judge also found that the first defendant had not provided a factual basis for its withdrawal, and against that background that was an indication that the claimant's claim was very strong. In my submission, given that the judge had found that the pre-action admission had been validly withdrawn, there was no reason for the first defendant to have provided at that hearing in February any evidence as to why the admission was withdrawn, and it had not done so other than providing the withdrawal itself, whether from the loss adjuster or otherwise. As is common course, when an application is made to withdraw an admission, you might often have evidence from the loss adjuster themselves saying, well, I made the admission on this basis and this new evidence has come to light and we withdrew it on this basis. That wasn't the application before the court in February 2024, and so there was no direct evidence from the loss adjuster as to the making or withdrawing of the admission. The evidence before the court was the withdrawal of the admission itself, and that can be found in the supplemental bundle at 262. This is an email from Simon Jenkinson, who was the loss adjuster at the time, dated the 19th of April 2021. And he refers to two matters. The first is on page 264 at little paragraph 8. He refers to the abstract consulting report. Now, the abstract consulting report was a report obtained by the claimant in January 2021. And so, therefore, between the date of the admission and the date of the withdrawal, and we can see that he summarises, Vault 1 showed no signs of water ingress and no water ingress to the vault had been reported. Vault 2 showed limited minor hairline cracking. The arches did not appear to show any significant sign of distortion. And therefore we do not consider that the report suggests that any structural damage to the vaults was caused by any works carried out to our policyholder. If your client considers otherwise, please can you explain the basis for this? Now that structural report is in your lordship's bundle at page 135. I should just say that whilst it's dated the 13th of January 2020 on its front, that is erroneous, and it's agreed between myself and
Sorry,
the
what
claimant.
page?
Page 135, milady. You can see over the page in relation to issue, revision and check, it's January 2021. It's simply
It's as reliable as most January dates.
right. The fog. That it is January 2021, and therefore it does fall between the admission being made and the admission being withdrawn. And the relevant page is at page 139 of the bundle. And we can see, and I will attempt to summarise, in terms of observations, one of the 2 vaults was not showing any signs of water ingress, and the claimant had not reported any water ingress to that vault. So there was no damage claimed at all in relation to one of the 2 vaults. Vault 2 had hairline cracks, and at 3.5, at the time of our visit, no visible water ingress was observed. However, the owner reported water dripping on a shelf after heavy rainfall. 3.6, the condition of the vault brickwork was not possible to determine due to the internally drained tanking system and plaster tile finishes. 3.7, the arches do not appear to show any sign of significant distortion. And then in terms of structural conclusions and recommendations, at 4.1, effectively the expert saying, well, we can't look at the structural condition of the vault because it sits behind some tiles. 4.2, we recommend that they're taking off in order for the condition of the underlying brick arches to be assessed. And then, importantly, at 4.4, typically Georgian brick arch vaults are not of sufficient strength to withstand modern traffic loads. And 4.5, we would therefore recommend that a detailed survey and analysis is undertaken to establish whether the arches have sufficient strength to withstand the loads applied over them. So that is the background report that came in between the date of the admission and the date of its withdrawal. In summary, the claimant's claim was now one for in excess of 200,000 on the basis that there had been structural damage caused to the vaults. And her own report in January 2021 was saying, well, we don't know if there's any structural damage caused to the vaults, we can't see any distortion, and you would need to take the tiles off and the tanking off in order to have a look at it.
Now, what's the relevance of this for the purpose of this appeal?
Well,
I can see that if the case goes forward to a trial, then you might want to rely on some of this stuff to say that there wasn't any negligence or the damage wasn't very significant. But I think the point we're on at the moment is whether the judge was right to say that there was no explanation for the withdrawal of the admission.
Right.
And
well,
was there evidence saying that, well, actually, the reason for the withdrawal of the admission was what we see in this report here, which shows that the admission was wrongly made?
Well, I can't go that far because this was the only email that was before the court, but causation together...
So, but the report was before the court or not?
The report was before the court, and the question of causation was before the court, and the question of quantum was before the court. So there was a submission made that at the time that the claim was brought, the claim was one for £30,000, and then following the admission of liability, that value of the claim increased to in excess of 200,000, and we can see that from the withdrawal itself.
Well, that's clear, but what I'm interested to know is whether you are submitting that the judge was wrong to say that there was no explanation for the withdrawal of the admission. And if you are, then what precisely was the submission that was made to him about what the explanation was?
Well, the reliance was placed no further than this email because this was the only thing that was before the court. So the submission was on the basis that causation had been raised, but primarily the value of the claim in relation to quantum had increased from a very modest 30,000 to in excess of 200,000. And that was primarily on the basis because the claimant was now alleging that there was structural damage caused to the vaults, and that is not something that she had evidence to support. So I accept there was no further evidence beyond that to which I am now taking your lordships, but these issues were raised at the time, and we can see that in the judgment of Mr. Justice Jacobs on page 76 of the bundle. It's his of the core bundle. It's his judgment at 8, 9, and 10. He refers to the admission, and then we can see that he refers expressly to the withdrawal, and in fact quotes parts of the withdrawal. That was, of course, an email that was referred to at the time. He then says the loss adjuster then referred to the fact that the amounts had increased significantly, and the admission of liability is therefore withdrawn. And then he says, in my view, crucially, at paragraph 10, there was in that email, as far as I can see, no factual basis given for the withdrawal, no factual basis which related to the conduct of the first defendant which had caused the damage. It was thus not suggested that some new facts had come to light which indicated that the first defendant had not been negligent in relation to the works carried out and the infliction of damage on the claimant. It was also not suggested that there had been some error or mistake on the part of the loss adjuster in admitted liability.
Is there anything in paragraph 10 which you say is wrong, factually?
Well, yes, causation, because it seems to me that there are three issues. One is negligence, and I accept that there is nothing in this withdrawal that deals with the question of negligence, but in my respectful submission, nor is there in the admission, which relates to accidental damage. But in relation to causation, there is, in my submission, enough in this withdrawal email to suggest that whether or not anything that the defendant may or may not have done had caused structural damage to the claimant's vaults was now in issue. But the primary...
well, he doesn't say anything about structural damage.
No, in terms of causation. And in relation to...
I mean, the judge has clearly got the point that the insurers are fed up because the claim keeps going up and up, and they think that the claimant is not vouching the losses that she's claimed and is being unreasonable. So there's an element of frustration on their part, which is all to do with the quantum of the claim. But does it go any further than that?
Well, my lord, yes. And I say even if it didn't, that doesn't make any difference as to whether or not anybody is entitled to withdraw a pre-action admission. So dealing with those 2 points separately...
No, we're not concerned with whether you're entitled to. We know you're entitled to. That's a given. But the question is whether there was an explanation for making the admission in the first place and withdrawing it in the second place. And I was just asking if there's anything factually wrong in paragraph 10. And if you think there is, perhaps you could tell me the words which are wrong.
My lord, yes. In relation to paragraph 10, in my submission, it is that there was no factual basis. Conduct of the first defendant, I'm fine with, which had caused the damage. It was thus not suggested that some new facts had come to light. Of course, there was the abstract consulting report, which indicated that the first defendant had not been negligent. I don't argue against negligence in relation to the works carried out and the infliction of damage on the claimant. So I say that in relation to causation, causation was something that was raised in the withdrawal and was before the court and doesn't appear in my submission to be reflected in paragraph 10.
Thank you very much.
But in relation to the factual basis for the pre-admission being withdrawn, notwithstanding causation, even if we were only dealing with quantum, that is something that was a valid reason for an admission being withdrawn. And we can see that not only from the authority of Gunn and Tay Group, which is behind page tab 1 of the authorities bundle.
Sorry, I missed that.
Tab 1 of the authorities bundle, page 13. At paragraph 36, this was a claim which had increased from some 600,000 to over 3.4 million. So there was a five-fold increase in quantum post an admission of liability. And there the court held that in relation to fairness to both parties, which one must have regard to, this was an application to withdraw an admission, I should say, is that at the time the admission was made, although significant in quantum terms, it was less than a fifth of what is now claimed. It is not at all unlikely that in September 2007, the defendant, its then solicitors and insurers, had known that it had faced a claim of over 3.4 million. It would not have admitted liability so readily if there was an arguable defence on the facts. It seems on balance somewhat unfair to hold the defendant to an admission of liability on a claim that's specifically quantified at some 600,000 when the claim over 2 years later is in fact increased fivefold. And that is reflected also in the decision of Wood, which was a decision of the Court of Appeal, which my learned friend relies on behind tab 9, page 137 of the bundle. The issue in this case related to the withdrawal of a pre-action admission which had been refused, and there was an appeal against that refusal. And we can see at paragraph 37 that the judge held that the decision to refuse permission to withdraw was erroneous, and at paragraph 38, what had been presented in 2010 as currently at a fast-track claim involving less than £25,000 had subsequently become in 2012 a claim in excess of 300,000. And over the page at page 138, we can see at the top, such matters involve questions of fact and degree. If one is facing a claim reasonably considered to be worth less than £25,000, it in fact seems but a total reserve of 16,250, that doesn't matter. At an increase of a few £1,000s might perhaps be acceptable and a foreseeable inherent risk, but a tenfold increase to over £300,000 is surely another thing altogether. And then we can see on page 140 of the bundle at paragraph 50 that the judge held that the entire change in character and amount of the claimant's claim was such to have justified the grant of permission to withdraw the pre-action admission. So against that background, I say that there was a factual basis for withdrawing the admission, both in relation to causation, because the claimant's own expert report from Abstract Consulting had suggested that there was no conclusive evidence of structural damage, and quite apart from causation, the arguments on quantum alone would have been sufficient had the matter come before the court for permission to withdraw the admission in order for it to be withdrawn. So against that background, then, I return to paragraph 30 of the Global Torch decision, which is behind tab 6 of the authorities bundle. And we can see in my submission that what Lord Neuberger is struggling with is how a court, when looking at giving directions or imposing a sanction, could satisfactorily take into account the ultimate prospects of success in a principled way. And in my submission, that word ultimate is highly relevant, because what Mr. Justice Jacobs was doing in this case was looking at the prospects on the basis of the evidence that he had before him, a snapshot in time when arguments of merits had not been raised. He was not looking at the ultimate prospects. He was not saying, well, I have a defence, I have the witness statements, I have the expert evidence, and I cannot see how this is a case that is ever going to, this is a defence that is ever going to get off the ground. It is one that's suitable for a summary judgment. He was simply saying, on the basis of what I have before me, that he thought that the merits ought to be taken into account. And in my submission, as is reflected in paragraph 34, that risks inherent unfairness to the first defendant, given that it was not provided with an opportunity to either serve a defence or identify what its defence would be over and above the withdrawal of the admission that we've referred to. Now, the claimant's argument proceeded solely on the basis that she could rely on that admission. At no stage did either the claimant or the judge identify that the first defendant had to answer any suggestion that its claim was weak on the merits or that the claimant had an unanswerable case. And in my submission, the judge's finding that therefore the first defendant had not provided either a factual basis for withdrawing the admission or a factual or legal basis for what its defence would be on liability was, in my submission, erroneous and unjust. The claimant's claim is one that is brought in negligence, and in my submission, in order to therefore assess the ultimate prospects of it, the court would need a defence, it would need witness evidence, and it would need expert evidence. That the essence of my submission is that the judge was not in a position to assess the ultimate prospects at a time where he didn't even have a pleading in front of him from the first defendant. Now, in my submission, that's to be contrasted to the very different situation that the court was addressing in the High Sarge case, and is the test that the judge applied, and is the test that my learned friend relies upon. And that is because where the court is assessing grounds of appeal, it necessarily has all of the evidence in front of it, that the underlying matter has already been argued, and therefore when assessing whether or not grounds of appeal are inherently very strong or inherently very weak, the court has the evidence before it in order to do so. That is very different from assessing the merits of a claim or a defence at a point in time when the court doesn't have those tools before it. And in the absence of those tools, in my submission, the judge was wrong and premature to make the finding that the claimant had a very strong case.
I was just looking at page 88 of the core bundle, which is the judge's reason for refusing permission to appeal. And he makes the points about the High Sarge case and so forth, but it doesn't look as if there was any submission made to him at that stage, that's to say post-judgment, making an application for permission to appeal, that it had been unjust for him even to consider the merits because there had been no advance warning about that. Can you clarify the position there?
Yes, my lord, 2 points. The primary basis for applying for permission to appeal, obviously on my feet at the time at the end of a judgment, was on the basis that the judge had applied the wrong test.
This was an extemporary judgment and you had to get up and do it straight away?
Yes.
Yeah.
It was on the primary basis that the judge had applied the wrong test, that had he applied the Supreme Court test, and given that he'd accepted that the admission had been withdrawn and therefore not capable of being relied upon for summary judgment, that therefore we ought not to have been looking at the merits at all. The secondary argument that it was unjust for him to look at the merits was not, to the best of my recollection, made at the time.
Well, it's a bit surprising if you hadn't made it because you hadn't made it during the hearing.
No.
So it would have been a bit surprising if you'd have
Quite.
sort of suddenly remembered it standing up immediately after the judgment.
No, and just to be clear, the reason that it wasn't made during the course of the hearing is because it wasn't raised by either the claimant as something that she was relying on. I accept it wasn't Ms. Farragon, it was Ms. Berzio. Ms. Berzio had not said, and even if I'm wrong, that I can't rely on the admission, nevertheless, you ought to take the merits into account because this is a very strong case. That wasn't a submission that my learned friend made, nor did the judge suggest that the merits of the case, the defendant effectively had a case to answer as to whether or not this was an unanswerable case or a very strong case.
Well, there might be room for a different view than the one my lord has suggested, because, and this is not meant to imply any criticism, so please don't take it that way, but one can imagine that counsel in your position sits there listening to the judge as he delivers his extemporary judgment, thinking to themselves, well, why is the judge going into all of this? We didn't deploy our case on what our defence was, because that wasn't an issue. He shouldn't even be going there. In which case, one might have. You might have wanted to make that point to him on permission to appeal.
Well, my lord, the submission was made that he was wrong to look at the merits.
But that's because
he applied the wrong.
It didn't meet the threshold.
Yes,
he thought it did, and you say it didn't, and that's your ground one.
But there was also a submission made that the word unjust was not raised, but there was a submission made that he ought not to be looking at the merits of the underlying claim because he didn't have a defence before him, because the time for the defence hadn't yet come, because the matter had been struck out. So how can one consider the merits of an underlying claim in the absence of even having before the court what the defence was? Why should, with respect, somebody in my position who is facing a relief from sanctions application against, on the face of it, very clear law that the merits will not be looked at, second guess that at the application, notwithstanding the fact that it hadn't been raised in my learned friend's skeleton argument, that if she was wrong that the pre-action admission couldn't be withdrawn, she was nevertheless going to rely on the underlying merits of the claim as being very strong, such that therefore that is something that I should have foreseen. And that is really the nub of my second ground, which is we were arguing about matters that hadn't been raised, and even if you're against me on my first ground, as a matter of law, ought not to have been looked at, because this was not a summary judgment application. It was not for me or my client to defend itself as to the merits of the claim in terms of getting over the threshold of a summary judgment application. It was not an application to withdraw an admission. Again, when it may or may not have been appropriate for the court to look at the merits. It was a relief from sanctions application, and absent express reliance on an admission, which she later conceded had been withdrawn, there was no argument that this was a very strong claim, and therefore the court ought to take that into account in relation to the underlying merits. That wasn't an argument raised, and therefore it wasn't an argument refuted. My lord...
So we're on to ground 3.
Thank you, my lady, which is exactly where I nicely... there are, in fact, 3, albeit I accept, interrelated arguments. The first is, quite apart from the law, quite apart from the procedure and the unjust, when you get to a relief from sanctions applications, the first limb of my submission under ground 3 is that the withdrawn admission was an irrelevant factor that the judge ought not to have taken into account. My second limb is that the fact that the defendant had not yet pleaded any defence was a factor that the judge overlooked. And then my third limb is that nevertheless, when weighing, even if you're against me on all of those points, that actually when weighing in the balance all the factors, the judge came to a conclusion that no reasonable judge could come to.
So really, it's little 3 that you need to cover now, because you've really covered 1 and 2 already.
Quite, my lady.
So balance.
Yes. So in terms of balance, we can see I'm on page 29 of my skeleton argument, which is behind tab 2. Now, these were factors which the judge accepted were relevant in his weighing of all the circumstances. The first is that not only was this a serious and significant breach, but it was a particularly serious and significant breach because the particulars of claim were not served by the claimant until 81 days after the deadline. They were served post-strikeout, and they were not served with the application for relief from sanctions. The second point that the judge took into account was that this was not a case where the claimant's solicitor had made a full and frank admission of her mistake. The argument that was being run all the way leading up to the hearing, not only in the application itself, but also in her supporting witness statement, was that the claim form hadn't been served at all, and therefore time for service of the particulars of claim had not started to run. And credit to my opponent, Miss Berzier, that was not a submission that she proceeded with in her skeleton argument, but it wasn't conceded by the claimant's solicitors prior to the hearing. This third point that the judge took into account was that, notwithstanding the fact that the particulars of claim were due on the 6th of July, those instructing me wrote to the claimant's
on that
solicitors
day, yes.
on the 7th of July and gave them a nudge, so to speak, asking where service of the particulars of claim were. And equally, they sent the application to strike out in advance on the 17th of July, and even that didn't prompt the claimant's solicitors into action. So the particulars were due on the 6th of July, and the application was not made until the 4th of August, so some 29 days later. And of course, the promptness of the application when making a relief from sanctions is something that the court ordinarily takes into account at the third stage. The fourth point was that the judge agreed that the mandatory factors in CPR 3.91A and 1B were factors, of course, as is always the way, that weighed in the favour of the defendant. This was not litigation that had been conducted efficiently or at proportionate costs, and of course there is a need to enforce compliance with the rules. And then points 6 and 7, the judge accepted that if the strikeout was maintained, then there wouldn't be any limitation problems with the claimant simply reissuing the claim form and starting again. So this would not be a situation where the claim was simply brought to an end because she was out of time for reissuing a claim form. And at point 7, the judge accepted the possibility that the possibility that the claim might be struck out for an abusive process would not in and of itself be sufficient to grant relief from sanctions. And the reason I say that he got the balance wrong is primarily when one contrasts the position of the second defendant and the first defendant. Because absent any discussion of the admission, the judge accepted that the admission alone, absent the admission, that he would have refused this application. And we can see that in his judgment behind tab 7 on page 83 at paragraph 49. He says, I should say that if the facts to which I have previously referred stood alone, and I did not have the admission, and certain other matters relating to the admission, I would have little doubt that the extension of time should be refused. So it was decisive. So in terms of when one looks at the position of the first defendant and one looks at the position of the second defendant, those applications side by side, the admission alone, the first defendant had already obtained a strikeout. And as per Mitchell, and I can take your lordships to it, it's at tab 3, page 44 of the authorities bundle at paragraph 45. In essence, what Mitchell says is, on an application for a relief from sanction, the starting point should be that the sanction has been properly imposed and complies with the overriding objective. So there was a shift in balance between the first and the second defendant. The first defendant had already obtained a strikeout, and so the starting point was that that was deemed a proportionate sanction, whereas of course the second defendant was applying to strike out, so the burden was on the second defendant to satisfy the court that the claim should be struck out. In relation to the serious and significance of the breach, it was far more strongly in favour of refusing relief for the first defendant because the particulars of claim were 81 days late as opposed to 33 days late. And the only other difference between the two cases was therefore the perceived merits. And in my submission against that background, a validly withdrawn admission and the lack of any pleaded defence, given that the claim against the first defendant had already been struck out, should not have made the difference between refusing relief in relation to the second defendant and granting relief in relation to the first defendant. In my submission, the admission was clearly decisive when, with respect, it was entirely irrelevant and it wasn't legitimate to rely on it. So against that background, I invite the court to allow the appeal and set aside the judgment of Miss Justice Jacobs and order that the claimant's relief from sanctions application is refused, which therefore would revert back to the original order of Mr. Justice Bright. I should say, of course, when one takes a step back, and looks, it is inherently unattractive, as Lord Neuberger said in the Supreme Court case, for parties to argue about merits on a relief from sanctions application, and in my submission, it would be unwise for all parties to necessarily seek to try and introduce that evidence at a relief from sanctions phase. Unless I can assist you any further, those are my submissions.
Yes, I'd like to ask you something. Would you look at page 126 of the core bundle, please? If you see there, under the heading Information for or Directions to the Parties, and the further heading Mediation, I answered that question yes, and commented it was a modest claim on any view which the parties would be well advised to resolve if they can without the expense of a hearing in the Court of Appeal. Can you tell me what action was taken as a result of that?
Yes, insofar as obviously the...
Don't give me any confidential details, but what I want to know is whether there was an attempt to mediate, and if not, why not?
There hasn't been a formal attempt to mediate. There have been other attempts to resolve the matter. The underlying claim itself is currently stayed, whilst not directly relevant to the appeal. It's relevant to the question that your lordship has just asked me. Following the decision of Mr. Justice Jacobs, he made a cost order in relation to those applications. That was a cost order that wasn't paid by the claimant, and so at the CCMC in June, before His Honour Judge Parfitt, His Honour Judge Parfitt made an unless order that unless those costs were paid by the claimant, then the underlying claim would be stayed. Those costs were not paid within the 28 days, and therefore the underlying claim was stayed. As of yesterday, and I'm sure my learned friend will correct me if I'm wrong, the principal costs amount, which was £30,000, was paid by the claimant, but the interest on those costs was not paid, and the direction of His Honour Judge Parfitt was that both the costs and the interest would be paid. And so the reason I'm explaining this is because there were steps taken, not formal mediation, there were steps taken, and then matters have been overtaken by the fact that the underlying claim itself, as things currently stand, has not been progressed following the CCMC in June because there was an outstanding cost order, which was paid yesterday, but as I say, that's not compliance with Direction 1 because it doesn't include interest.
Right, so at the moment we're arguing about relief from sanctions in a claim which is stayed anyway.
My Lord, yes, that is not, however, something which I rely on for the purposes of my argument. This is an academic argument, but yes, taking a step back, the underlying claim is currently not active due to a failure to pay a cost order.
And to revive it, there will need to be payment of the outstanding costs plus an application to lift the stay.
There will. There will.
And the answer to my Lord's question is?
There was no formal mediation.
Well, I don't tick that box very often, but when I do, I don't do it for fun.
No, my Lord, I accept that. I accept that, at least on the first defendant's case, a claim which is, even if she is successful, probably not worth much more than £30,000. The fact that we should have had various applications for relief and various CCMCs and unless orders and cost orders, I accept that the difficulty is there is only so much my client can do.
Yes, and you referred to the judge's order and the cost, so you got the costs of the application
we did
for relief against sanctions.
We did.
So there was that element of surviving sanction, as it were, for the failure to serve the particulars of claim.
Yes, my Lord. Just for your note, it's on page 37, the order of
Yes.
the supplemental bundle. The claimant was ordered to pay the first defendant's costs arising out of their application and our application. And then what happened, just for entire transparency, what happened was he ordered that go off to be dealt with on paper, and there was a consent order as to the figure, which was £30,000, as between the claimant and the first defendant, and then the claimant failed to comply with her own consent order.
Yes. Thank you very much.
Yes, Miss Conway.
My lord, my lady, I'm grateful. Have a moment just to stop there. Appreciate it.
Of course.
My lady, my lords, I'm grateful for my learned friend for having set out a good chunk of the background to this case, and I'm grateful that you've had the opportunity to have gone through the papers in some detail. So I will try and cut through matters quickly where I can. However, just before I set out a roadmap to what my submissions are going to be, just propose we take a step back for a moment and look at actually what we're dealing with. Here there has been an admission by an experienced loss adjuster, and that admission itself is not something to be taken lightly. It is a serious and significant step in the process of any litigation to admit at any point in proceedings that liability has been conceded. That, when coupled with the fact that this is a relief from sanctions application, where the consequence of which would have been a strikeout, was in respect of the strikeout of a claim, that is a very draconian, serious sanction. What we have is a serious admission and a serious sanction. Both of those factors aren't light factors, and indeed weren't light factors that were taken into consideration by Mr. Justice Jacobs. However, heading to the main point of my submissions, in respect of a roadmap, I intend to address you really on 7 elements. They do broadly follow that of my skeleton argument, save to say that the submission in respect of the factors Mr. Justice Jacobs relied upon will be dealt with slightly later in my submissions, as I envisaged that point could be quite short. So to start with, I'm going to look at the relevance of the pre-action admission, really looking at what the admission was, the context of the withdrawal, and then secondly, in respect of the context of the civil procedure rules and how that admission, yes, was withdrawn and withdrawn validly, but it was withdrawn validly on the basis that the defendant could simply hold its hands up and say it was withdrawn. The second part of my submission is likely to be take up a little bit more time, and that's namely in respect of Denton and all the circumstances, and that's going to be 2 parts. The first dealing with the question of all the circumstances and really how this withdrawn admission can still come into play in relation to all the circumstances. And then secondly, it will deal with what I'm calling the merits test, so to speak, and how Mr. Justice Jacobs rightly took into account merits and could do so in line with the case law. The third submission is going to be on the approach that should be taken to case management decisions. Again, I anticipate that this point can be quite short. Fourthly will be the point in regards to the factors that Mr. Justice Jacobs relied upon. Again, I'm not seeking to take you through those in any great depth, just to outline them, so that should be quite short. Ground 5 will be that Mr. Justice Jacobs' decision was ultimately correct. It may be that some of my submissions can be dealt with quickly. Essentially, this is in conclusion to ground 1 of the appellant's appeal. Ground 6 will be that the decision was just. Again, that's in response to ground 2. It may be that a lot of matters have already been covered by that stage. And similarly, in respect of submission 7, that Mr. Justice Jacobs correctly exercised his decision. That's still going to be the roadmap to my submissions. So to start with, namely the pre-action admission. And if we can begin with the admission itself, though I envisage the court's already relatively familiar with that, but that's a supplementary bundle at page 168. 169, my apologies.
Thank you.
And it is the second paragraph that we are concerned with. We must advise that legal liability for the accidental damage is conceded, and this will not be raised in the future. What here is a very clear and unambiguous admission that really is two parts. The first being that legal liability is conceded, but then the defendant goes beyond that assertion to bolster it by saying that it will not be raised again. And I appreciate my learned friend's comment that the admission may have been made, because ultimately we don't have the reasoning before court as to why that admission was made, and I appreciate that. However, in respect to the submission that it may have been made for commercial reasons, to me seems untenable. At the end of the day, this is an admission to liability. The appropriate action in respect of a justifiable commercial route would have been to present an offer. This is different to that. It should be treated differently because it is more significant. Following the admission, there were discussions between the parties. I don't seek to take you to those. And then we have the withdrawal of the admission on the 19th of April 2021, and that's at page 262 of the supplementary bundle. It begins at 262, I should say. And that is the email in which the withdrawal of the admission is contained. But what we'll see, and I'll take you to the relevant sections, is that even in this withdrawal of the admission, the withdrawal email itself is really focused on quantum, which was the finding that Mr. Justice Jacobs made. So, for instance, if I can start with the second paragraph at page 262, namely, the purpose of this correspondence is to set out the quantum information that we need from your client in order to progress the matter. There's no indication at the outset of this withdrawal email that the purpose is anything other than quantum. It does then go on to detail the different heads of loss and provides comments upon those. However, for instance, as you'll see, the passage taken in respect of page 263, underneath point 4.4, we then have the comment, for the avoidance of doubt, we do not consider that this is a justifiable head of loss. The point being that they want evidence from the claimant as to quantum and as to that loss. The issues being raised really are heads of loss which are a matter of quantum. Furthermore, within that email at page 265, underneath the heading of quantum itself, there is a statement, the first line of that, our policyholder and subsequently Sedgwick attempted to engage in constructive negotiation to resolve the matter, leading to an admission of liability. Now, it may be for constructive dialogue, but again, an admission is a serious step. It's not something which is taken lightly, and it's not an acknowledgement there that the admission was erroneous. There is then, furthermore, the second sentence of that. However, whilst your client has made considerable reference to the admission of liability, you will appreciate that this does not absolve your client of the need to prove that breach caused the loss complained of and prove the loss itself by way of evidence. Again, the focus being on quantum. And that's furthered by the last sentence of the second paragraph under quantum, with an admission of liability should not in itself cause the amount claimed to increase. The point being, as you may already have gathered, that even within the email itself withdrawing the admission, the concern really is in relation to quantum and not liability. Now, that's not to say that there won't be a defence to liability, but there's not one that's actively put forth within the very email which draws the admission. And if we look to the section on liability itself on the same page, in particular, again, the last sentence, so paragraph 3 of the last sentence on respect of liability. Accordingly, in light of your client's unjustified complaints and unwillingness to adequately evidence their claim, whilst our client remains willing to engage in pre-action correspondence in accordance with its obligations under the civil procedure rules, the admission of liability is hereby withdrawn. The very sentence in which the admission of liability is withdrawn is concerned with what is the client's evidence in respect of loss. So there's no explanation there, and again, I don't wish to say that there cannot be an explanation, but the point being that before Mr. Justice Jacobs, there was not an active advancement of a reasoning as to why liability is now in dispute. That the withdrawal itself focuses on quantum. And again, if I can take you back to the core bundle to Mr. Justice Jacobs' decision itself, and in particular, this is behind page 76 of that, behind tab 7. And the key passages are really passages 8 through to 10, though I don't seek to describe them in detail to you. Aside from to highlight paragraph 10 in particular, there was in that email, as far as I can see, no factual basis given for the withdrawal of the admission of liability. In respect to no factual basis which relates to the conduct of the first defendant which caused the damage. That's not an incorrect statement based on what is said within the withdrawal email itself. So there has not been an incorrect finding on that. And my learned friend seeks to rely on the authority of Gunn and Tay Group that the admission was validly withdrawn, and I accept that is correct, it was. And the point of that case being that where there's been an increase in quantum, that's enough to justify the withdrawal of an admission. But that in and of itself still does not go to the question as to whether or not there is going to be a case or not on liability. And ultimately here we aren't concerned with whether or not to strike out a defendant's defence. We're looking at this through the lens of relief from sanctions, which is essentially to indulge the non-compliant party. And there is a little bit of a concern that we're going to become too muddled in the idea as to whether or not the admission was withdrawn, when it is in agreement that it was. But nonetheless, there's still a significant amount of questions to be answered surrounding the withdrawal, that the basis on which the withdrawal is on liability appears to be unanswerable at this stage. In respect of the merits of that, I will take you to that in respect of Denton, just so that I can keep it all contained in one. But the crux of the submission on the admission and the withdrawal and its context is that there's been a pre-action admission by an experienced loss adjuster, bolstered by the assurance that it won't be raised again. Yes, albeit it was withdrawn, albeit validly, but in circumstances that really address quantum as opposed to liability. And that's the key context here for the relief from sanctions application. Now, in relation to the second part on the admission, really it's to look briefly at the context of the civil procedure rules which were in place at the time, opposed to what they are now. And the aim is really to show that there's been a shift in the rules, because there is an inherent unfairness and unjustness to what would have been the claimant in this situation for an admission to have been withdrawn without an explanation. And again, I don't seek to persuade you that the admission is not validly withdrawn. It was, but it's just for context as to where we're at. And if I can take you to those, the In relation to the old rules, all that was simply required of a case of this kind to withdraw a pre-action admission at the stage of proceedings it was at was a statement along the lines of the admission is now withdrawn. That is key. If I can take you to the new provisions, and again I will try and be brief on this given that it's not necessarily a point in dispute, but they should be behind within the authorities one tab 10. And in particular starting at page 160. And again, just to clarify, these are the rules post-October 2023. You have at 14.1 that the withdrawal of the pre-action admission is effective essentially where the admission, where the person to whom the admission was made has agreed. And if it's not, then what the court will look to is the factors within civil procedure rules 14.5, and that's at page 166. And in summary, these are looking to the grounds, whether there's new evidence available, the conduct, any prejudice caused, what stage they had reached, the prospects of success of the claim, and whether it's in the interest of administration of justice. My apologies to jump a little bit, but if I can take you back to page 161, you have at 14, in the guidance at 14.1, in the last paragraph really describes the new effects of the rule. One practical effect of the rule is that it gives a claimant confidence that they can rely on a pre-action admission made under it in the knowledge that it can only be withdrawn either with their permission or after proceedings have begun with the permission of the court. This in turn may limit the need for them to spend time and money and in continuing to investigate and gather evidence in relation to that particular issue. So it's clear that the new rules, which again weren't in play during that when the withdrawal took place, are seeking to address an unfairness in respect of the claimant.
I'm afraid I'm a bit lost as to what the relevance of this is, given that these were not the rules in place at the time, and it's common ground that the admission could be and was withdrawn. I mean, there is a question whether, the question is whether that admission is a circumstance within the meaning of stage 3 of Denton, where you've made the point that it was made by an experienced loss adjuster who obviously thought there was, Ms. Boone would say accident, but you've shown us a message which talks about breach of duty, which is pretty clear language. I mean, why do you need to go further than that? That's either a good point or not.
My lord, I appreciate the question. The main point of taking you through the new rules is really as to context, as to that in respect of the admission itself, it has not been through the new process. It's simply been withdrawn on the basis that it can be withdrawn by stating it's been withdrawn. It may be in fact that I do not seek to go any further on that point, aside from saying that it's important context if it was at the forefront of your mind, as to how that withdrawal took place and the fact that it would have had to have gone through.
But before the judge, well, it's in the run-up to the hearing before the judge, before it was accepted, as he records at paragraph 11 of his judgment, that it's now common ground that the defendant, first defendant, doesn't need the effect of the court's permission to withdraw the admission. Was it your predecessor's case or argument that the new rules applied?
My apologies for cutting across. My lord, my understanding is that the council previously was arguing that the old rules in respect of 14.1a applied, which was where to withdraw an admission you'd need the court's permission, but only in certain cases. I think there's been then a misunderstanding as to whether then that extends beyond those cases into this one.
Right.
but yes, in any event, it was a submission which I understand was resiled from, and correctly so. It was withdrawn correctly, and it is valid.
Thank you. Now, so we're moving on to Denton, are we?
Yes, my lady. In respect of Denton, there's going to be two main submissions on this. The first is looking to whether or not this validly withdrawn admission can come within the scope of all the circumstances. And then the second is to address arguably the main point of the appeal, which is the merits claim and whether or not those can be taken into consideration. So to deal with the first submission in respect of Denton, namely all the circumstances, I propose that we start with the wording of the Civil Procedure Rules 3.9 itself. I appreciate you may very well be familiar with this, but it is in the authority bundle behind tab 10 at page 143. The wording of that is stating that on application for relief from sanction, imposed for any failure to comply with any rule, practice, direction or court order, the court will consider all the circumstances of the case so as to enable it to deal justly with the application, including those factors at A and B. The point there being that in respect of the use of the word all, there is no bar within the Civil Procedure Rules itself as to what a circumstance of the case can be. Ultimately, regardless of whether or not the admission was validly withdrawn, it is still a circumstance of this case that there was an admission, that there was a withdrawal, and that withdrawal was valid. It doesn't change the nature of that. The fact that it is validly withdrawn does not change the nature that there was, in fact, an admission during this claim. And that's somewhat is reflected within the case law. If I can take you to the case of Chartwell Estates, and that's in the authorities bundle at tab 4. And in particular, if we can take you to page 60. The focus really being on paragraphs 56 and 57. In relation to the decision of Justice Globe in that case, it states, on the contrary, he reached his conclusion that it would be too severe a consequence when set against all the background history and the other matters listed by him. In my view, that background, that is all the circumstances of the particular case. It is clear that background factors and background information to the case, which in this case, again, to save me sounding like a bit of a broken record, but is the admission and the withdrawal. Furthermore, in respect of all the circumstances, if I can take you to Denton itself, it's at tab 5 of the authority bundle. Page 74. In particular, paragraph 36. It's stated by Lord Dyson, Master of the Rolls, and Lord Justice Buck in the joint judgment, that the factors, it's always necessary to have regard to all the circumstances of the case. The factors that are relevant will vary from case to case. So yes, there is a question in regards to whether or not it is relevant, but nonetheless, the fact of the admission and withdrawal is a factor which can be taken into consideration. And in respect of its relevance, the reason advanced as to why we say that it's relevant to be taken into account is there's really four main reasons for that. First, as I've already been through, is that yes, there's the withdrawal of the admission, but it goes really to the heart of quantum as opposed to liability. Secondly, we have the context to the admission and the withdrawal. And in respect of those, we have the two reports. I'll take you to those in a moment. Apologies, I'm just finding my reference. So you have the report from the 13th of January 2021, which is at page 135 of the supplementary bundle. I appreciate my learned friend has already taken you through that, but particularly at paragraph 3.8, which is at page 139, we have the statement that we understand that the carriageway resurfacing of Upper Wimble Street carried out by others took place earlier in 2020, and the water ingress commenced shortly after these works were completed. That as a statement in respect of causation would be quite significant in pointing to the fact that there's some element of liability that is likely to have been incurred by the defendant, the first defendant. Again, that's not to say there's no defence to that, but in respect of causation and the timeline of events, the fact that the water ingress started after the work took place by the first defendant is a strong point in respect of liability. And my learned friend is taking to paragraph 4.4, which is that typically George and brick arch vaults are not of sufficient strength to withstand modern traffic loads. But that has to be read in conjunction with paragraph 4.5, which is we would therefore recommend that a detailed survey and analysis of the brick arches is undertaken to establish whether the arches have sufficient strength. So although there is mention within that report arguing as to a potential basis put forth by my learned friend for liability, it still does not provide an answer for liability, and certainly does not absolve the first defendant of any argument that they are liable. And what we do also have, which was before the court, was an even a more detailed report, which is contained at page 145. And that's dated the 16th of December 2021. And if we can take you to where it states the basis of report, the third sentence down, in those writing the report have in excess of 35 years personal experience in the construction industry.
Sorry, I've lost the page.
Oh, my apologies. It's page 145, my lord.
Sorry, 45. Sorry. Yep.
I'm grateful. Yes, underneath the heading of basis of report, this is a report that has been produced by an individual of in excess of 35 years personal experience in the industry. And then if I can take you to page 147 of that report. And we have in respect of items for separate consideration. Whilst attendant, it was suggested that subsequent to the roadwork execution damp penetration has been experienced beneath and around the previously unaffected painted surfaces, it is entirely logical to assume that the embedded waterproof layers have been damaged, fractured by virtue of the excess traffic load and significant and sustained vibration recorded during the works. And again, that is something that was for Mr. Justice Jacobs in giving his judgment. Furthermore, at page 149 of the report,
Was it? I mean, was this material gone into before Mr. Justice Jacobs on the merits? My understanding is that he dealt with it on a very much broader brush basis, which was the admission, plus the fact that somebody had looked at the vaults before and they were fine, and that the water started leaking when it rained.
My lord,
Almost res ipsa loquitur, to use the phrase we don't like to use anymore. But I don't understand that he went into all these reports, one produced by your side and one produced by the other side. That sounds like exactly the sort of exercise which he's not supposed to go into, and didn't.
My lord, I appreciate that. The point to be made is that those reports were, however, available to Mr. Justice Jacobs. It's more to...
Yeah, but was he taken to them and with a view to saying this is a very strong case?
My lord, as far as I'm aware, I don't think he was. I wasn't present at the hearing, but the indication from my learned friend was to suggest that he was not.
No.
The point really to make is that if my learned friend's ground of appeal is that the decision was incorrect, that firstly, if we look to the broad brush documents being the admission and the withdrawal, it's insupportive that there's still a very strong claim. But if we also look to the additional documents that was before him, and I appreciate he's not been taken to those, and that may be going into more of a detailed investigation, but even his finding in respect of the broad brush approach is backed up when we look further to.
Well, I'm not sure about that because I haven't read all of this report, but I see that the very next paragraph after the one that you refer us to says, however, this is technically beyond my remit. So you're on very dangerous ground if you are relying on this report, it seems to me.
I think for my part, both of you have now referred to these reports in your submissions to us in circumstances where they weren't relied on or part of the judge's analysis. So for my part, speaking for myself only, I'm not finding it very helpful from either of your point of view.
Well, lady, I'm grateful for the indication. In that respect, I will leave the report as it is. Aside from, I would just like to point out at page 149, paragraphs.
Well, I thought we weren't going to go to the reports.
I'm grateful, my lady. And the third reason as to why the consideration, take it back to why the consideration of the admission and its withdrawal is relevant, is because without the consideration of the admission and without the consideration of the subsequent withdrawal, in effect what we have is a defendant escaping liability for a claim which it previously admitted. And if we can take you then back to Denton, behind tab 5, paragraph 19. Page 71. And here, Chartwell is quoted. I don't seek to take you to the exact quote from Chartwell, but for your reference, Chartwell's is contained at tab 4, and the passage quoted is that from page 61 to 62. And the point that I wish to draw your attention to is that it is stated it's to be emphasised that the courts, in considering applications under Rule 3.9, do not and should not have as their sole objective a display of judicial culture. The objective is to achieve a just result, having regards not simply to the interest of the parties. The interest in this case to the defendant would be quite significant, but also to the wider interests of justice. Ultimately, it's every defendant's dream to be in a position where it originally accepted liability for a claim to now being in a position where they have nothing to do with that claim. And I appreciate this is not to diminish the fact that sanctions are valid. I don't want to create the impression that in every case, simply because of an admission, that what results from that is essentially non-compliance is condoned. That is not what I wish to do in any sense or any respect. But the admission and the withdrawal in this circumstance, given that it goes to the heart of quantum, really is of benefit to the defendant to have the claim not continue. And it's important to note that the operation of the Civil Procedure Rule 3.9 is to indulge the non-compliant party, not as a reward for the defendant.
Thank you.
And in respect to the advantage to be received, if I could take you to the case of Chartwell Estates, and that's behind tab 4 of the authorities bundle. In particular, page 61, paragraph 61. And then what I'm going to do is read from line.
Would you like us just to read that paragraph to ourselves? Would that be?
Yes, my lady.
Yes, that might be helpful, mightn't it? Thank you.
My lady, I'm grateful. And the point here to be made is that the advantage to the first defendant here is even greater, because it disposes of not only an unwelcome legal action, but a legal action which it initially accepted liability for. And that's important to be taken into account, and it's relevant in therefore assessing whether in all the circumstances the court should indulge the non-compliance of the claimant. In respect, therefore, of all the circumstances, unless there can be any further assistance on that point, I propose to move on to the merits test.
Yeah, thank you.
I'm grateful, my lady. So the second sub-issue is what I'm terming the merits test. And in short, the submission is going to be that merits can be considered as part of all the circumstances under Civil Procedure Rule 3.9, albeit I do appreciate what is referred to in the authorities, that namely if we were to embark on a detailed investigation of the merits, that it would in some instances be undesirable to. It takes it beyond the realm of simply case management. And if I could start first by taking you to the case of Abdul and Commissioner of Police of the Metropolis, and that is in the authorities bundle behind tab 8. And in particular paragraph 20, which is at page 126. And in that passage, Lord Justice Lewison specifically references the case of Global Torch. Citing the last specific factor he took account of was the strength of the underlying claim, which he considered at 41. Now, the passage that he references in respect of that for Global Torch is that at paragraph 29, and that's at page 93 of the authorities bundle.
Sorry, paragraph number?
29, my lady. And again, my learned friend has taken you through this paragraph already. The key elements being it's generally irrelevant. The fact that it is generally irrelevant does not, in my submission, mean that the merits of a claim cannot be taken into consideration. And no doubt it will be a matter for the judge hearing the application as to whether or not to take into account merits in regards to the relief is appropriate. There's no bar by simply stating that it's generally irrelevant. And what is And although the judge in Abdul criticises, not quite criticises, but states in effect that it was an unfortunate use of phrasing to have looked at the merits, what needs to be borne in mind about that case is that it was a case where the judge had stated that it was all but ready for trial. To consider merits at that juncture would have been a strenuous task based on documents before it in any event. But really, the heart of the submissions in respect of merits lie within the Global Torch case.
I'm not sure. Isn't it paragraph 20 you've just taken us to? I'm not sure that's in your favour, is it? Because all that Lord Justice Lewison is saying is that the judge at first instance just simply said he couldn't say either way, that the claim was bound to fail or bound to succeed, and that was really all he said.
Yes, and
so, I mean, it's actually not saying that there was no endorsement of looking at the merits in any material way.
that's correct, my lord. In respect of that, though, given that it references back to paragraph 29 of Global Torch, the point from Abdul really is that in referencing it back to the point about being generally irrelevant means that although the decision of Abdul is correct, it does not mean that there's no scope for merits to be considered. And here, given that in Abdul he couldn't determine whether or not there was an answerable case or not, that's important as to why they perhaps shouldn't have been considered and was an unfortunate use of phrasing.
But I understand Lord Justice Lewison to be saying if the judge at first instance had actually said anything more about the merits than I just can't say whether it's either at one end of the spectrum or the other, that would have been wrong or unfortunate because it would have cut across what's said in Global Torch.
That may be correct, my lord. However, what should be borne in mind with that case is that that case was one where it was all but ready for trial.
Really, Lord Justice Lewison is saying that this is a serious case which is pretty much ready for trial, and striking it out is a disproportionate sanction. And Lord Justice Lewison says, well, he wouldn't have made that decision if he'd been the judge, but the Court of Appeal won't interfere.
Yeah.
That's all you really get from that, isn't it?
Yes, my lord. Okay, if I can take you back to the case of Global Torch itself, back to paragraph 29. Again, I've already been through the sections specifically relevant. That one possible exception, however, is what I want to deal with next. Could be where a party's strength would entitle him to summary judgment. The point to note about that is that the one possible exception, that's not to say it is the only exception. And in respect of summary judgment, in our claimant's case, summary judgment could not have arose yet anyway. For summary judgment to have arose, it would have had to have been the acknowledgement of service or a defence filed. We're not that far into proceedings yet, because there was no particular claim that had been served. And so we say, in any event, that in respect of summary judgment at this stage, if we were to import a summary judgment test into what is essentially the very early, a little bit earlier than the summary judgment usually allows for, the claimant in this case would have met that because of the admission and because of the withdrawal, and the circumstances of the admission and the withdrawal are such that the claimant had a very strong case. And again, I don't seek to take you back to the admission, the withdrawal, and the circumstances, as I've already been through those with you. And if I can also reiterate paragraph 30, again, just to summarise that paragraph, essentially what the court is looking at is to whether or not they can satisfactorily take into account the prospects of success, and also whether it is in effect proportionate to do so, given that the concern is whether or not these applications would cost more and take up more time. Here, what we say to that is, firstly, the factors can be satisfactorily taken into account based on the documents that were before Mr. Justice Jacobs. And I appreciate my learned friend's contention that there is no defence before him, but that's precisely a fact that he couldn't take into account, therefore. So in assessing and taking into account those factors, he did so correctly.
Sorry, did I understand you to say a little earlier, a minute ago, that although there wasn't an application for summary judgment, if there had have been, this case would have met the test?
On the basis, yes, my lord, on the basis of the documents that it had before it at this stage, the issue would be, and I do appreciate my learned friend's view on this, is that summary judgment would not have been able to have arisen yet, because it's not at the stage of proceedings whereby which summary judgment can. For summary judgment to arise, there'd have to be no prospect.
It's not a question of stage. I mean, are you saying that on the documents before the judge, the merits are sufficiently clear that the case is unanswerable, or was?
Yeah, yes, my lord. And that's bearing in mind that the documents before the learned judge was that of the admission and that of the withdrawal that were considered, we'd say considered in full. The letter of the email in relation to the withdrawal was clearly
Unanswerable.
considered.
Unanswerable to what quantum?
In relation to liability, my lord. There may very well be a dispute as to quantum, but there is still an unanswerable case based on the circumstances of the withdrawal as to liability. And given that the admission goes to liability, that's what we'd say is important.
Thank you.
And again, there's further clarification from Lord Newberg within the case at paragraph 31. I don't seek to take you to that again in much detail. It essentially says the same thing as to whether or not there's a strong enough case. And again, then in respect, therefore, of the merits, again, I don't seek to take you back through the admission and the withdrawal. I've already been through those in depth. But on the basis of the documents that Mr. Justice Jacobs had, we say that the finding that there was a very strong case was correct. And in addition, I think it'd be safe to say that the fact that the defendant in the first place made an admission as to liability is a strong indication that the claim is likely to be very strong on liability. And again, and I say that without any prejudice to the defendant in being able to bring a defence which does contest that, but at the moment it's not clear. Again, you have the reports which were before the court. Again, I don't seek to take you to those.
Why were the reports put before the court? I mean, I was reading it a little earlier through the witness statements, and particularly as I understand it, the witness statement of not got her now.
Miss Joel.
Yes, it's the witness statement that seems to be in here of Miss Johal, Louise Claire Johal.
Yes.
And if my bundle is correct, the reports were exhibited to her witness statement.
Yes, my lord.
And it said that these are a paginated bundle of exhibits with references made throughout the statement, and I just couldn't actually see where she referred to those reports or for what purpose.
Yes, my lord. In respect of that, those instructing me currently, there has been a change in solicitors, so unfortunately I can't take express instructions on that. But I think it's safe to say, as a witness statement, it's not the clearest, I think.
Well, it doesn't. It doesn't actually refer to the report. It doesn't,
yes, my lord.
I mean, to pick up the point that was made against you by Ms. Boone, I mean, it doesn't. I was checking. It doesn't say, look at these reports. This is a really strong case, irrespective of the question of the admission, which is the subject of a dispute. I mean, it doesn't say that. It doesn't actually refer to the reports at all, as far as I can tell. Have I missed something?
No, my lord, you are correct. And as I say, I can't unfortunately take express instructions as to why those reports were added in. Aside from said, as Okay,
And-
I think it's fair to say it's not the best witness statement on
No,
dealing
but
with release from sanctions.
also in response, given that the witness statement of Mr. Yoel didn't actually say, look, this is why I'm referring to all these reports, and look, it's a really strong case, see what the reports say about X, Y, or Z. The witness statement in opposition, I don't think, went into the merits either, did it?
No, but it does acknowledge withdraw the admission as being a mistaken admission, which is something of a new factor. I can get the page one moment. Is it 195? That's at 195 of the supplementary bundle. Paragraph 18. I appreciate it doesn't expressly deal with the merits. However, it does acknowledge that, in effect, that liability, the admission in any event was, we say, an issue for that hearing.
Okay, thank you.
I'm grateful. And in respect of what I will move to, in respect to my learned friend's submission, that there's no reason to believe that the defendant would have had to introduce evidence in respect of the merits. If I can take you first to the application notice itself, which is at tab E of the supplementary bundle.
Tab what?
Tab E. Melanie.
Thank you. Tab E. Oh yes,
E.
I have it. Thank you.
It's at page 118, if that's any easier. And in respect of section 2, the claimant seeks an order to set aside the order of Mr. Justice Bright, alternatively relief from sanctions. And at section 3, there's a clear element of this where it states further the first defendant is stopped from defending the claimant's claim on the basis of a previously open admission of liability. So the issue as to liability and the reasonings around it, we say based off that, were in dispute, and as such, the first defendant had noticed that merits could be in consideration. And then if I can also take you to the witness statement which accompanied that, at specifically it's page 122. It starts at 122, my apologies. Page 129. At paragraph 58. What we have there is a statement by Ms. Johal that all the circumstances of the case favour the grant of relief, particularly the early open admission, which is dealt with below. The reference to all the circumstances of the case, we'd say, is clearly getting at the test in respect of Denton. Or in any event, the circumstances of that and the circumstances of the admission were going to be raised before court. Whether or not the defendant chose then to introduce evidence was a matter for that.
Thank you.
I'm grateful. And just really to look at the final case on merits. And that is in respect of the case of Highside. If I can take, again, the key passages of that, it's behind tab 7 of the authorities bundle. And the key passages begin at page, we say 117, and it's mainly paragraphs 46 through to 53. got the reiteration from Lord Justice Morbick, paragraph 46, which is in effect, if extensions of time applications are to develop into disputes about merits, they will occupy a great deal of time. The point being already made from Global Torch, that the concern really in regards to considering merits is how much time this is going to take up. There's no bar within any of those paragraphs as to merits, that merits cannot be taken into consideration.
Thank you.
And again, and I think you've already been taken to this passage, but the learned judge within his judgment specifically refers to that case, and again the judgment is at tab 7 of the core bundle. At page 80. In particular, paragraph 31. And it's clear from that there need not be a detailed investigation of the merits at this point, because the court had the admission, had the withdrawal, had the fact that it was made in circumstances where these are experienced loss adjusters, and that being significant because the withdrawal was not accompanied by the factual explanation as to why he's now in the defence on liability. The only additional matter to add in respect of merits in terms of its context is that if we're looking here at an admission and a withdrawal, the merits to that are going to be intrinsically linked to some degree. In order to consider the admission and to consider the withdrawal will naturally evolve into a consideration of merit. And it may be you do not need to make a finding on this, but it might be that for a judge not to have considered the admission, or to have considered the admission and not the withdrawal in the documents that they're contained with, and to look at the merits of that wouldn't have been dealing with the case justly. And in respect of my submissions on merits, I don't seek to add anything further unless there's anything I can be of any further assistance on. I'm grateful. I do appreciate that it is 5-1. I am happy to deal with case management.
I think that can be dealt with pretty briefly, can't it? I think everyone's very familiar with.
Yes, my lady. In that sense, the point to make on the third submission of case management decisions is that there is a wide discretion afforded to judges, and the intervention should be reasonably limited. If it is of ease, if you're familiar with the authorities, may I just give you the passage references for your note, if that's of any assistance. So we have the case of Abdul, Police Commissioner, and that again, tab 8 of the authorities bundle, page
paragraph 29.
Yes, and 24. And the point at paragraph 24 really is that even if a judge would have come to a slightly different decision, it has to be more than just, as long as it's a reasonable decision in effect, that's okay. Again, paragraph 25, and that as well, 26, which again is quoting really from Mitchell, which is we start by reiterating a point made before, the court will not likely to feel the case management decision. There's also paragraph 27 of Lord Justice in quoting Chartwell. So the passage from Chartwell is behind, again, tab 4, the authorities bundle, page 62, paragraph 63. Again, the Court of Appeal will not interfere lightly with those decisions. Aside from that, it is addressed within my skeleton argument, and it is those passages which I contain there, and for reference, the paragraphs that I rely upon in my skeleton argument are at page 45 behind tab 3 of Court of First Law Bundle. And it's paragraphs 58 through to 62. Again, the point simply being that there should be reluctance to intervene
Thank you.
They do.
Very well. Two